if this is a case, so what we can do? It is saying that precedent must be based on the law. The decision that we have taken in the previously was on the law, not on the fact. Obviously, the fact has pushed it to the law, and that law has made a decision considering all of the fact or everything that is there in the case. So directly it is there. Directly the fact are affecting, but the decision which was based was on the law. So whenever we are going to follow the decision, so we will be considering which law was applicable there. Huh? Okay. Then we will look at the fact, the nature, the characteristic are similar or not. Huh? And that will further defining the same thing. This is something dealt over here. The previous court must be superior in the hierarchy than the court using the precedent. This will allow it to bind the lower court. But here they also have said that it can be done through the senior court or other equivalent court. If it is the equivalent court, in that case, it will lead to the persuasive. Hana?
Yes. Okay.
Okay, done?
Yes, sir.
Perfect. For a precedent to be binding, the material fact, the main fact of the previous case and urgent case must be same, because ultimately the fact will define the law which will be applicable. If at first place the facts are different, if the facts are different, how can a simple law, a single law will become applicable? No, na?
No, sir.
So in that case, if the facts are different, so in that case there is no decision of the previous decision, right? But if the facts are same, in that case we will look around whether the law is applicable or not, and then from the law to vice versa we will see, because ultimately law will define you. If this is happening, this is something you have to grant. Then after the law, you will look around, okay, in this fact this is happening, so this is what we have to decide on the law basis. Okay, so if they vary greatly, in that case it will not be binding. But if there is a no difference, a major difference, or the facts are similar or some sort of similar, in that case it will be binding. So there are two things: identical and similar.
Okay.
So similar would be like the same, but there will be some difference. Identical means you would not be able to find the difference between the two. Okay, identical, very identical. Okay.
Okay.
Huh. So what is the role of statutory interpretation? Statutory interpretation talks about like how the interpretation of the law, because law is there, we have to read it. Every time the judges is going to form the decision, they have to read the law and they have to interpret it according to the fact, right? And it could possible the single law can have a slight difference of the meaning when you're dealing with a different case, because ultimately this is something you will see that a law, when followed for a different case with a different fact, would be making a different decision, right? So that's why we first look for the fact, then we go to the law, and then from law to fact we basically look around and we give the decision. So this is basically the flow. Okay, so it is a process where the judge gives meaning to the ambiguous, I don't know how to pronounce this word, or the phrase in the statute. So when there is a law, and in the law, inside the law, when there are some words which are unclear or something which is not clear perfectly, so how are we going to give the meaning to them? It is based on some of the rule, and some of the rule are below. The very first one is the literal rule. It says that as per this, the word must be given their normal dictionary meaning, even though resulting judgment is undesirable. So you just have to open the meaning for every word that you think is unclear in the law. You just open the dictionary and just look what is the meaning of that word, and then you will be applying or understanding or interpreting the law according or keeping with that meaning what is there in the dictionary. You do not have to think otherwise. Okay. Hello, done. So to better understand this, listen to this short podcast by the FinSort, which explain a case in India where the court had to interpret the meaning of the midterms. David, we will study this case study. So the case study that you will study now and further in the classes, this will give you or prepare you for section B. Okay.
Okay.
So mostly 80% you will see the case study will be helping you section B. 20%, 50 to 20% can help you in the section A. Okay. The case study, basically from the case study, you do not have to learn the name. You do not have to learn the number, the year. All you just have to learn the rule plus application. Okay.
Okay.
And rule include two things. What is the rule and what is happening? So what is happening? This will lead to the rule. So that is altogether a rule. And plus, because of that rule, what is application is happening? What is a held decision is there? Something you something you have to remember from the case studies that you will be learning. You do not require to know the case study name or the year. This will not be asked in the paper. Okay. So these are the fact. Fact means something. The case knowledge. What was happen now? Okay. Hello.
Yes, sir. Yes, sir.
The court has to consider the meaning of the word offer to sale. It was an offense tha, to offered for sale offensive weapon. So if you are going to offer to sale the offensive weapon, in that case it will become the offense, right? A shopkeeper has flicked knife which with price tag attached on display in his shop window. So when you will be reading the contract terms, so in that case you will be learning about there are two things: offer to sale, when you are offering to sale, and invitation to treat. Okay.
Yes, sir.
Invitation to treat, you are inviting the other party to come and have a discussion about the product. And offer to sale is basically something when you're very specific about the project. Okay, I'm ready to sell this no matter what it is. Okay. Invitation to treat, whenever we're going to display anything on the window, this is supposed to be the invitation to treat, right? This is not an offer to sale. Then the main difference between the offer to sale and invitation to treat, this is what happened first, this is happened at the second. So invitation to treat is something when you're inviting other party to have a discussion on. This is more often the possibility of coming to the negotiation, right? But here there's a no negotiation. This is an exact offer you're giving, a more detailed one. Okay. So
Yes,
would
sir.
it be okay we just give it a single reading over here till now?
The court had to consider the meaning of the word offer to sale. It was an offense to offer for sale offensive weapon. The shopkeeper had flicked knives with price tags attached on display in his shop window.
Okay. Now
Yes,
the
sir.
court applied the fundamental principle. Fundamental principle means they have followed the literal rule. Literal rule means that they have just opened the dictionary and just taken the basic meaning of the word. So the court applied the fundamental principle of contract law in literal fashions, accepting that the display of flick knife was an invitation to treat, and it was the customer who made an offer to buy. In consequences, the shopkeeper was found not to be acting illegal. The aim of the parliament, however, had to be prevent sale of offensive weapon. Okay, understood?
Okay,
Hello,
sir.
understood?
Yes.
So remember, what was an application? The invitation to treat is basically something, not an offer to sale. And when you're
Okay.
doing the offer to sale, it will, and when you're doing offer to sale of some weapon which are illegal, in that case you are doing an illegal act. So this is something you
Okay,
have
sir.
to remember. A good case study, when you will be reading it again, it would become more clear. Golden rule says that when the literal rule gives more than one meaning or provide an absurd result, means unclear result, the golden rule is used to ensure that the preference is given to the meaning that does not result in the provision of being absurdity. What do you mean to say? That you have a word, example, ABCD word there, okay, in the sentence, okay? Hello. So you have to
Yes, sir.
understand the sentence, because the meaning of that word would be having 1, 2, 3 different words. So you have to understand the meaning of that word in the best way possible, where it is giving you the clear meaning. You do not have to select the option out of the three which is unclear. Okay. If you just read the case or just which is given, a conviction was challenged on the basis of what appeared to be miswording in the official secret act. Okay. This act
Yes,
made
sir.
it offense to obscure a member of the armed force in the vicinity of the particular location, but not actually in those locations, right? So can you able to see in those particular location and but not actually in those locations? The defendant was actually inside an air force base at the time of incident, which he claimed was beyond the literal scope of the act. The held was that in the vicinity of a prohibited place in the official secret act were held to cover the act of the defendant which took place within the prohibited area, right?
Yes.
So better if I just say this to you. The golden rule. You will be given the 2-3 meanings, so you have to select which would be more relevant to or which will be more fitting into the world. Okay. If there is any other thing that we can understand from this case study, I would like to take the screen and just would like to go to the Copilot and just understand what they're trying to say. Okay. Done?
Yes, sir.
Because ultimately, if we could have one single more statement that could explain or make it as easy for us, and it would be good. Okay. Though we have tried it understanding, but let's see what they're trying to say. Listen. What they're doing. Hello.
Yes.
Would you please read it?
Golden rule. If using the exact words, if the law gives strange or unfair results, judges can tweak the meaning slightly to avoid them. Adler versus George, the law said it's a crime to block soldiers in the vicinity of a protected place. The person was actually inside the protected place. He argued the law didn't apply. The court said vicinity includes inside to avoid nonsense in the law. It's like fixing awkward wording to make the law make sense.
Okay.
Yes.
Now we will move ahead with the mischief rule. So it is basically used to interpret the statute, means the law, in a way which provide a remedy for the mischief, wrongdoing. So there was a wrongdoing happening. Okay. So mischief rule says that because of the wrongdoing, we made a law. Yes or no? I told you about basically law are made on the loopholes. So we have to understand which word would be stopping something from the wrongdoing. We have to apply that meaning. Okay. Used to interpret the statute in a way which provide a remedy for the mischief wrongdoers the statute was framed to prevent. So the reason why we have made was to prevent something. Okay. So we have to make the or take the meaning which basically going to prevent something happening from wrongdoing. Okay. Is it okay? Hello.
Yes.
If I just say this, the case, the Contagious Disease Animal Act 1968 provide that any ship-carrying animal should contain them in pans. The defendant neglected his duty, means he has performed his duty without a due care. Okay, and some of the claimant sheep was overawed and lost. Right. Since the purpose of the statute was to prevent the spread of contagious disease and not to guard against the danger of the property being was abroad, the claim failed, right? Seems like an unclear to me. So what was happening there? If we try to again, the Contagious Disease Animal Act 1968 provide that any ship carrying animals should contain them into pens. So pens is basically logged, right? Hello, understood?
Yes.
So basically there was a requirement that ship need to be contained in the pants, right? But defendant has not kept into the pants. Because he has not kept into the pant, the ship got lost. Because of the ship got lost, claimant is claiming because I lost my ship and it was the neglect of the defendant. Because of the neglect of the defendant, now the claimant is claiming that I want money or the compensation for the ship I have lost. But was this covered in the act, or it was just because that we have to keep the ships into the pen just to ensure that the disease is not getting spread around? So it was because the disease will not get spreaded, but the claimant is claiming something like that, okay, I have lost something, I have lost my SIP and I want the compensation. So this claim by the claimant will not be approved, because ultimately the act says that the requirement to keep in pens, just it was because to ensure that the disease is basically spreaded from the animals is not getting spreaded. Okay, understood? Since the purpose of the statute was to prevent the spread of the disease, to stop, है ना? And not to guard against the danger of the property being was abroad, the claim got failed. The claim of the claimant. Okay, understood?
Yes.
Then purposive rule, it does mean that whatever we're making has a purpose. So we have to look forward how the meaning will mean to achieving a purpose is something we will be taking care of. It's a modern approach wherein the court passes a judgment based on the interpretation of what was the interpretation of the parliament when passing the statute. So whenever they were making a law, they had an intention to achieve, right? So this is something we will be looking into the purpose. So what was the purpose of bringing the law will be considering, okay? The purpose of an act was to provide the safe storage of the films of the film where it might be stored on the premises. The claimant argued that premises did not include the cave, and so the act had not application to this case. The purpose of act was to protect the safety of the person working in all places where the film was stored. That was if the film was stored in the cave, the word premises include the cave as well. Okay. Then we have Alstom. Generally, something Paris and France were maybe. I don't know. I'm not clear. Maybe Paris or something. I think France is that it is so. So it is said that general word mean the same purpose as a specific word they follow. So sometime you will see that drink and eating not allowed over the metro station or something like that. So it does mean that you cannot eat or drink anything. Now when you're eating burger, when you're drinking cold drink, so these all things are invalid. They cannot be drank, right? Because this is something they have written over here. Even though drink and eating food has not specified which food to eat, which not to eat, but they mean you cannot eat anything or you cannot drink anything. Huh? Understood? Hello?
Yes.
So what they're trying to convey that it is state that general word mean the same purpose as a specified word they follow. Okay? Section 1 of the Betting Act 1853 prohibited betting in a horse, office, room or other places, right? Hello? So you cannot betting of the horse in office. So you cannot have a betting in house, office or room or other places, right? The issue was whether a ring at the race course was an other place for the purpose of this statute, right? So house is a closed place, yes or no? Office is a closed place, yes or no? Room is a closed place, yes or no? So other place would be something closed place. But a ring or where the horse course was there was an open land, yes or no? Hello? Hello, Samvit, are you there?
Yes.
So there is a closed place and open land, right? This is a concept that you have to keep when you're dealing with this case study. The law decided that if the enduism Chinese rule was applied, the specific words such as room, office that preceded the general phrase of or other place created the class of indoor place, right? Something very close or in something indoor place. As a ring on a racehorse was outside, it would not fall within this category. Okay. Therefore, the act did not apply to the restricting the gambling here. Understood? Something very important. Hara?
Yes.
So it could possible that they might give you the same example of this, and they might ask you that which rule is applicable on that. So you have to talk about this rule is applicable. Huh? Something for each and every rule which is there, and these rules might be tested. And I have seen questions coming on these areas. Okay, important area.
Okay.
Then we have an expresso unius exclusion ulterius, whereas statute seeks to stabilize the list of what is covered by provisions, then anything not expressly included in the list is specifically excluded. What do you mean to convey? There is a list, whatever you have included, the list will only limit it to that only, okay? There is nothing you will be adding by your side, okay? Hello? Understood?
Yes.
Hello,
Yes.
hello, hello. So there are some presumptions, right? So what is the difference between presumption and assumption? Would you like to Google it?
Assumptions is something that we are assuming.
Hmm. Presumption has some base, right? A more strong base that we are dealing with. Good. So they are the presumption which will generally apply unless legislation specifically state otherwise. So if there's a different law, in that case, the law will become or prevail. Okay. If there is no specific law, if there are uncertainties, there is a no law, so we will be using some presumptions. Okay. Hello. Understood?
Yes, sir.
Samit, please acknowledge here. So what are those presumptions? That a statute does not alter the common law. So whatever the law you are making by the parliament will not be changing the common law unless you have made the law with the intended intention of changing the common law. Okay. A statute does not exclude the jurisdiction of the court. Okay. Jurisdiction means the country that we are going to rule out. Legislation does not extend beyond the territorial jurisdiction of the UK. Obviously, a statute will not bind the crown. Okay.
Yes.
It will not bind the crown. Okay. Because ultimately crown will be the one who is going to judge or give the decision on the basis of the law. The law will not be binding the crown something like in the favor of themselves, right? It could not
Yes.
possible that a law will be making a binding a court that they can do something. Law cannot define what the court will be doing, right? Hana?
Yes, sir.
If anything is given, then if anything is given about the court, that is only in the constitution. Okay. A statute cannot conflict with the international law. An act should therefore be interpreted as giving effect to the international obligations, right? A statute does not have any retrospective effect. Okay. Retrospectively means the law cannot go back and change the previous. You cannot go to the previous day and change anything. Okay. You can change from now to onward. Okay. So whatever the law you are making, for example, there was a common law. Now Parliament is bringing up another law that will change or that has an intention of changing the common law. So you cannot go back and change the decision of the common law, right? The previous decision which was taken on the common law. What you can do is follow from now onward to follow the made of the Parliament at the place of the common law. Okay, done? Hello, done?
Yes, sir. Yes.
These are the two questions which you need to answer, and you will be answering these two. If an act says that the milk, curd, and cheese and other things prohibited in the medical store, it is the sale of the buttermilk allowed. They are saying that in the medical store, the provisions are on the milk, curd, and cheese. So can a buttermilk can be sold there or not?
No.
C and D.
No. Because it is a meaning product.
And which rule is going to be applied on this?
The animals.
Done. Wonderful. I'm impressed, brother. You're doing so great. I'm happy for you. If we talk about the second one, if an act says that one must not dispose of rubbish in public place and claim that his friend talks rubbish out of the different meaning of the word rubbish, the court interrupt it as a waste material. What they're trying to say that the rubbish would be having different meaning. Out of those different available meaning, the court has interpreted or they have taken this as in rubbish means something waste material. So what is an statutory interpretation here? Right of a person to have a friend who don't care about their ex. Literal rule, get a life, you lost life. Act, golden rule. So what is that? The item of preceding other things is into whether. Give it a try.
Literal rule.
Waste, I think.
Or golden rule. It can't be
one of
A
them.
or C.
D.
No.
There's a word rubbish has a various meaning, and as per the golden rule, the most appropriate meaning was chosen. Golden, no?
Okay.
Literally is that what does the dictionary says? Golden means something you have to select the one which would be talking or bringing the sentence meaningful. Okay, the law sentence meaningful. Done. Hello.
Yes, sir. Yes, sir.
Now we will just quickly cover this page. Okay. Saria law is something we will be doing tomorrow. Okay. Not tomorrow, next class, and then we will be done with this chapter so that we can start with that. I will try to wrap up this tomorrow, today only if you are okay to take an extra class today. We will see. I will just quickly get you through. Okay. So what is a civil law? It is historical developed from the Roman law. The principle of civil law, it is a comprehensibility and certainty. The question we were doing tomorrow is coming from here, na? Comparability and certainty. Okay. Law contained in the course. These are the law contained and they are formed as a generic principles applied in any suitable situation. Certainty means they are laws should be decided predictably in reference to the above mentioned courts, right? What are the source of civil law? These are the constitution of the company, European law, statute, administration law, custom of the land. Okay. The custom of land was there also in the common law. Okay. So role of judges means role only apply the law, just create precedent which need to be followed by the court. So their law was interrupting the law. Now here the judges will only apply the law. Judges are not supposed to interrupt the law generally. Okay. There in the common law they were doing that. Hana? However, the interpretation is required. The judges may identify the social and historical purpose of the law and apply it. Okay. If you talk about the principle of the judicial interpretation in general terms, judges are not supposed to interpret the law but apply it. However, with some interpretation is required, judges are required to identify the social purpose of the law and apply it manner to ensure the purpose is enacted. Enacted means achieved. Okay. Here the enacted means achieved, where implemented. Okay. You have to think about when you are studying or just trying to decode the law language. It's going to be a bit difficult, but it can be done when you will be doing it very frequently. Okay. Also, judge may look at the historical intention of the law, why it has bring, and seek to apply it in the way that it would have been drafted to cover the modern situation. Is that okay?
Yes.
Now, if we just quickly go through what is the difference between the two. So common law and civil law, it is origin in England, origin in Roman land. Just can be interpreted the law. Judges are not supposed to interpret the law. Used in England, India and USA, used in Germany and France. Civil law also used in there, but the main root are this one, okay? For this two. As judge can interpret the law, it is more flexible and can adapt it. Yes.
The second point.
This?
Yes, sir.
Yes, please.
The judges can interpret the law. What does that mean?
So like interpretation means something they are going to use it. There were some presumptions, right? For an example, ultimately, see, the basic or the practical thing is that judge is going to read the case as well, the law which has become applicable. They will try to interpret the law in accordance or in the context which is there. In the common law, you have to follow the case law, the previous case laws as well. But in a civil law, you have just law from the parliament. In the civil law, you do not have any case law. So you have a law, you just bring or start applying it according to the case requirement. But in a common law, sometimes you have to interpret according to give the best decision. Just a slight difference between the two. Okay? Hana? As judge can interpret the law, it is more flexible and can adapt the justify. Interpretation means they can interpret. Means there were different rules that we have done, golden rule, another rule, Hana? But in a civil law, you just directly applying that according to the case that is given. These are not very flexible, but these are the found. Okay, something easy that we can have. Now, if I just quickly go through the cues, so what is going to be the British code in the order? So the very first one is that सबसे पहले तो आता है हमारा European code, okay, European Union. Then it comes to the
Supreme Court.
Which one? Supreme Court. Okay.
Supreme Court.
Second, then
Crown Court.
No, Court of Appeal. Second, and these are for third. Okay.
Okay.
Then we have a Sharia law. Would it be okay if we just quickly finish this, huh? Because then we will be done with the very first chapter. Please.
Okay.
Would it be okay if we can bear it like last 10-40 minutes, because we will be done with this portion as well. And so that we will be having something new to start by Monday. So, okay. Because we need to cover on this. Sharia law is basically, they talks about what is the law that is followed in the Islamic, okay?
Okay.
Sharia law is based on the Islam. It given by the Allah. It is used in several important countries like Saudi Arabia, UAE. These are sources of Sharia law. These are the Quran, Allah divine message to Prophet Muhammad. Okay, okay. This is one of the leader. There is social leader, religious leader. Okay. So Sunan means it is a record of what come to be acceptable course of conduct driven from saying the Prophet known as Adiyat. So Adiyat, who is known as a Prophet, they are the Prophet Muhammad and Prophet Adyan. Basically, they talk about what is accepted, what is not accepted. Madhab is basically the school of thought based on the teaching of Islamic jurists. Jurist is basically the person who is an expert of the law in their religious, and boldly they are the two schools, Sunni and Sui. The Sunni from the majority, the school under the Sunnis can be further subdivided into the Hanafi school and Maliki. So basically, they talk about how the Islamic law is teach or taught into the Islamic countries. Okay, so who is the leader and all those things, right? Okay, and then they basically follow the constitution of the country. This is very specific to the country that they are following, and most probably the Pakistan would be having the constitution law, and other than that, they will be following the Quran, Suran, and Madhab and constitution of the India, constitution of the specific country. Done. Now the point is that what will be the role of this? Is there anything that you want to do? I think you have something to ask.
No, sir.
Or can we move ahead?
Yes, sir, we can move.
Role of other judges means judges are generally caret, means these are the religious leaders. Some countries also have a scleral shariks, right? Sharik means the religious leaders. Judges only apply the law. Okay, this is a FAQ in the exam of the civil common law Sunday law, so you better memorize it. Okay, so who is going to apply the law? Judges will apply the law, and you must know these small things. They might ask you who is the jariks, right? They might ask you who is the religious leader known as an, okay, they might ask you about what is a Quran, they might ask you about what is Sunnah. Once I have explained you, all you need to do is remember the definition of all of these things, right?
Okay.
The power of the interpretation is limited as the law is established by the himself. So one cannot interpret what Allah has said. Then we have an interpretation of the law. If clear guidance is not available in the Quran, it means religious guru may refer to the Sunan to confirm and explain or clarify the law. If the Quran does not give guidance on a specific matter, Sunnah may do so. It can be a caution. What can be or who is going to give the guidance when the guidance is not there or available from the Quran? So it will be the Sunnah. So these are the questions that can come up. Within the Sunnah, the hadith are classified according to their reliability. Muwatarit are virtually guaranteed, and mustar are less certain, and others have little certainty about their reliability. Something might seem worky for you, but something need to remember. A constant revision of the same thing will give you. There are certain things that you have to learn where we cannot do anything other than learning them. Okay. There is a controversy in the Muslims world whether the further interpretation of the law may be required. The lead is the theory that the law has been interpreted sufficiently and does not require further interpretations. Izajat are the historical process under the interpretation of the law. This specifically type of izajat are izam, was ityan, maslaha, mursaha, urf, itisab. Okay. Hello, Deo.
Yes.
Would it be
Yes.
okay if we start this class again just for the next 10 to 15 minutes? Okay.
Okay.
Done.